was established in the year 2004 under the aegis of Rohini Educational Society. GIPS is affiliated to Guru Gobind Singh Indraprastha University, Delhi, and is approved by All India Council for Teaching Technical Education, Ministry of HRD, Government of India for Technical Programs, and Bar Council of India for Law Programs. The institute is conducting programs like MBA, BBA and MBA integrated, BBA, BA LLB, BBA LLB and LLM. The college is accredited A grade by NAC and rated highest grading A by Joint Inspection Committee of Government of NCT of Delhi and GGSIP University. Gives rational approaches that may be useful in both learning and research-based teaching of law. The accessibility barriers and knowledge gaps faced by researchers shall also be identified by the resource person and discussed in detail along with possible solutions and reforms wherever necessary. The program aims at being instrumental in introducing the participants to the emerging horizons of legal research and research methodology and providing them sufficient awareness of the same. The program will provide a good Sir joined Delhi Judicial Services in 1992. Sir was later on promoted to Delhi Higher Judicial Service in 2006. During his tenure, he was deputed as the Director, Administration of Delhi Judicial Academy. Post his retirement in 2021, Sir is currently working as an arbitrator and mediator, as he is a trader mediator. He is also the Director of Mundona Rural Development Foundation. I would now like to request Professor Dr. Ravikant Gupta to give a brief welcome to Sir.
Depends upon the ability of its teachers to transfer their knowledge to the students. If you have, let us say, a large gap between the knowledge you have and knowledge you are able to transfer, it would indicate a kind of a failure on your part. And if you can transfer the knowledge you have to a greater extent, then you would be called as a successful teacher. For example, a teacher has, let us say teacher A has X knowledge and he is able to transfer that knowledge to the students, let us say 50% of that knowledge. Then there is another teacher goes continue. And he is able to transfer that knowledge to 70% of what he has to his evolve to a better teacher. So the entire exercise of any faculty development program is to ensure that how much of that knowledge you have, you are able to transfer to the students. Now, I've been a part of the Judicial Academy itself for many years. I've been part of the faculty development programs at National Judicial Academy. I'm a fellow of Commonwealth Judicial Education Institute. And I can say with some insight into it that entire exercise of faculty development program can be summarized into this, that to increase your ability to transfer your knowledge to the students. And you can define it in three parts. You can say, first part is the knowledge itself. If I have deficit in my knowledge, will I transfer? That's question number one. So the knowledge itself becomes part of the component. The second is the pedagogies you have. That I learn different techniques to transfer that knowledge. And the third and the most important part is that how do you prepare the students to receive that knowledge? You are saying so many good things. You have great knowledge about the subject itself, and yes, transfer of knowledge we possess to the students, and how do we increase that percentage of transfer? It will never be 100%. It will never be. But our always endeavor is to ensure that this percentage of transfer increases, and that we do by learning various techniques of teaching itself, which are more engaging for the students. That's one part of it, the technology or the methodology to teach. One, to yourself, that how do you increase that knowledge component which you intend to transfer, and third is preparing the students to receive that knowledge. And that's also a very, very important part of it, that how much participating you make your sessions, that's also very, very important. And how do you ensure that they're listening to you carefully? If they're not listening to you carefully, then probably they will not listen to the knowledge. So there are many, let us say, hurdles you have for transferring that knowledge, and this entire exercise is to overcome those hurdles in the first place. So the success of any faculty development program depends on how much have we learned on all these three aspects. Now I'll just move on to what we are here to intend to talk about, which is the areas of dispute resolution system, development of ADR and recent trends. Now you will see by yourself that it is quite an open-ended topic we are talking about, and therefore what we are expecting is to go through what has happened over a period of time and what is happening right now. That is what our attempt is right now. And so therefore, if you have any questions at the end of the sessions, you might ask, although we have lost some part in the model itself. But let us see how it goes from here and how much time we have to talk to each other about these things. Now, it has already been said that I joined the Judicial Service Center in 1992, and I had joined the Judicial Service Center in 2006. Now, around that point of time, around 2006 and a little bit before that, the mediations trainings had already started in Delhi. And I remember that we had people coming from the United States, some of the faculties coming directly from there, and we have the first line of mediators being cut or clicked. This is 2004, 2005. So I was perhaps we remember that around that period of time, we had to talk to the lawyers face to face, sitting across, and convincing them that mediation is a viable thing, and this is a new future for you. Not for us. We are judges, we are paid anyway, but this can open new avenues for you to be mediators, and we have to convince them. And we had the first batch of lawyers also being trained as mediators. And suddenly it caught on. And now there is a kind of a competition. Whenever the lecturing programs open, there are many people who want to be mediators. So things have changed over a period of time. But I'm talking about 2006, 2007, around that period of time, but how much of resistance you have to this new method of dispute resolution system in which now, I'm still a mediator, in that sense, we said it, Separate Mediation Center, I spent 1 day in a week at the Separate Mediation Center, and also at the Grand of Maybe International Mediation Center, we are AC, and also providing that, and there are some mediations from there. So that's what I do right now, Mr. Kant. Now, around the same time, around 2006-07, I was so much fascinated by this whole idea of the alternative dispute resolutions that I wrote 2 articles. One of them was qualities of a good mediator. Probably is still available on the Delhi District Court's website. You might go there and check it out for you. And it shows that if you want to be a mediator, what qualities you should have. So that's one which is there. And then there was another article which I written, which was, I'm not too sure if it is there on the website, but you might still look at it. And what I written was, is called Why I Hate Alternative in Alternative Dispute Resolution. So it was kind of fun, somebody commented, why do you want to hate some alternative in alternative dispute resolution? Because I had realized at that point of time that, and it is a common experience of all of us. I'm pretty sure that out of the lot we have right now, many of you must not have ever gone to a court. You have never gone, you never had a litigation. And you can find a whole lot of generation of people, if you ask them, oh, never been to the court. I never had a litigation before. So would it mean that there had never been any dispute in their whole life? Can we say that? It's impossible. We always have some disputes, some discourse, some differences of opinions, always. But do we go to the court? We don't go to the court. What do? We resolve those disputes out of the court. So which is the main? The most of the disputes get resolved not in the court but outside the court. So which is the alternative? The court or the other methods they brought for the alternative dispute resolutions. And the second point which I tried to make was that court has the limited ability to resolve disputes. The courts cannot resolve disputes of all shapes. They cannot do it. For example, there is a landlord-tenant dispute. Now the landlord is on the first floor and the tenant is on the ground floor. Now somehow the landlord wants this tenant to be evicted. So he adopts a way to harass him. He overwaters his plants every day in the morning, and the cold water will drip down on the ground floor. Now the tenant wants to stop this harassment and says, no, I go to the court and get an injunction against him that he should not overwater his plants. You tell me that is it possible alternative. So these are 2 points I raised, and I said, this is the reason. This is the reason to say that we should give it the what we so-called alternate dispute resolution matters. We should give them a due place, an independent mechanism to resolve disputes, rather than being treated as something alternative to something. And this will bring in more innovation into the subject. You will find out more and more ways to resolve disputes. And incidentally, I remember I was in Japan and talking to some people there, and they have a very innovative way of resolving disputes. What they had that some people write into the villages as kind of volunteers. Now, there is a family dispute, they will focus on repairing the relationships, improving the communication. In a way, let us say there is a family dispute where the mother-in-law and the daughter-in-law are not doing well. So they will try to focus on the family values. They will try to focus that you repair this relationship. If there are neighborhood disputes, to try and resolve those, repair those relationships. And the idea was that if you repair those relationships and improve that communication, then perhaps the disputes will get resolved in their own way. So therefore you can find out not just define the categories of the labels you have for the dispute resolutions, you can find much more ways to resolve those disputes and make them independent of what you have also. Now, I remember I was in a conference in which IIJPS minister was there, and he was talking about, he was saying that we need these new methods of resolution of disputes to reduce the burden inputs. So what he used the expression, which I still remember, is that these are like bypass surgeries. That if the system is clogged, then you create a bypass surgery, you take cases out of the system and resolve them in any other way. And my argument still remains that these are independent methods of resolving the disputes. The fact that by these methods being adopted to reduce the burdens in the court is only a byproduct. It's only a byproduct. There is a method which is available that also helps in reducing cases in the court. It's only something you are utilizing it here. You don't create it for this purpose. That's my point. The other methods of resolution of disputes exist not for the purpose of reducing the burden in the courts, but they stand on their own. Now, you know that when it comes to the legislatures, for them, the courts always remain an issue. And to that extent, the courts are heavily burdened. There are so much of pendants which is taking place, and therefore they want to utilize these ADRs, so to say, to reduce the burden in the court. And that has been the legislative framework we have seen being created over a period of time. For example, it begins with section 89 of CPC itself. And the section 89 of CPC was introduced for this purpose, that whenever there is a list before you, whenever there are litigants before you, you will try to find out the elements of settlement within that dispute, and then you will appropriately refer them to different channels of ADRs. So they could be local government, they could be arbitrations, they could be conciliations, they could be mediations, any of that. So you find out which is the best method to do that, and you will channel all those disputes in those directions. And sometimes I used to joke that it is something like we have no always the money that Jaishankar
आगे इधर जाओ आपको पीछे. So something of that kind. That once you have a dispute, before you find out that which channel should it go. Should it go to arbitration, should it go to conciliation, should it go to mediation, and so on and so forth. Now again, when we're talking about the mediations here, we're specifically talking about co-annexed mediations. We're not talking about the mediations per se as such. So these are the mediations which are annexed to the courts. And Section 89 gives the power to the courts to refer them for the mediations. And you know, I have already spoken about it, that there are structures which have been created by the administration which are annexed to the courts themselves, where these cases can go and the mediations can take place. And if there is a settlement, it comes back to the court, and the court passes the order in the light of the settlement which has been arrived at. If they are not settled, they are just said that as not settled. And then we have, I just highly recommend, you can please put it down somewhere for us. This is called, popularly called Afghan's judgment. Afghan's judgment. Have you read it? Anyone of you? Afghan's judgment? So please read it. Please read Afghan's judgment. And I highly recommend it. This is Afghan's first section division. You can find out the citations on the road. You all have Google and bias with us. But nevertheless, if there is a requirement, I will send it out to you. That there is no escape from reading the Constitution. Precisely for the reason because Section 89 has been reinterpreted in a different way in which the language has also been tweaked here and there. So that's one reason also to read it. And the second part is it prescribes the ways that how will the disputes which you have in the bill will get referred to different areas and what will be the consequence of it. Like for example, if with the consent of the parties, you have referred a dispute for, let us say, arbitration in that sense. Then if it is an arbitration, it will never come back to you. It will never come back to the court, it will go out of the court system of the court itself because arbitration will come to, it will result into some kind of a war which by itself is executable by the court as a legal. So therefore it need not come back to the court itself. Similarly for conciliation. And it also talks about the disputes which are good for mediations and so on and so forth. And sometimes the disputes which should not be referred to mediation. Like for example, we just talked about an example of landlord-tenant dispute. This is one kind of a dispute for which the court may not offer a remedy for it, or at least efficient remedy. But there are disputes like you have applied for letters of administration or a probate. In those kind of cases, obviously the legal civil authorities is the agency through which these things are conducted. And I just like to, as researchers, I just like to point out that I ask you to go through the figures which are available on the website of, let us say, the legal service authority. Just go to the figures and look for it whether this has been actually successful, whether the numbers reflect that it has been successful, whether it has generally has served any purpose, or it has just become a way of, let us say, a suit getting delayed as a result of it. And the institution mediation comes at a cost. The parties are expected to deposit cost for the mediation. And there is a range which is available. It's according to the value of how you value that application, according to which of the parties, whether it gets split as a separate issue. But nevertheless, the parties are expected to deposit that cost before you go into the institution. So, and now it is mandatory, let us say, earlier than that, there is a difference between the high courts and
different high courts saying it is mandatory, saying it is not mandatory, so on and so forth. There has been some confusion and so at the level of the judges also whether this should be treated as mandatory, although the language is couched as something mandatory. But there have been some arguments that this is something like a procedure, so if somebody is filed to throw him out, so on and so forth. But now that stage is gone. Supreme Court itself has said it is mandatory, so it has to stay, and there is no escape. But I just to give you a taste of the figures which are available for the month of June. If you look at the figures available on the website of the daily district leaders in 2005, that there were 2 cases which were settled. There were 2 cases in which the mediation failed. There were 592 cases which were non-starters. So you can imagine how much purpose this has served. And anyway, there is a section 89 which is available to you, which anyway, when the suit is in the process, which will force you to reconsider with the parties in settlement law. So whether 12A was overdoing, so there was something available, was 89 was it something which came in without actually the necessity? That's what we need to look at it as researchers, like how much of it, and we look at the figures from the time of the section 12A came in. By the way, just explaining to you the 3 categories: settled, failed, and non-starter. Non-starters will be cases where I accept, you will notice that the become medium doesn't come. So that's kind of a non-starter. So the 3 categorization, there are also mediations, rules which are appended to the act itself, and I will encourage you to read those rules to understand it, that how this entire thing has been conceived and whether it has actually delivered the results we were looking for. Now, let me just again, like I said, it has become a legislative policy to introduce such measures. You see that we have Consumer Protection Act 2019, Minimum Related Section Consumer Protection Act 2019. So the Consumer Protection Act, it was earlier 2016 Act, then came 2019 Act, and when the 2019 Act came in, they also introduced a separate chapter by itself for mediations and creating a mediation set. And there were defined categories of who qualify as the mediators. That's also there. And then you have the separate chapter like I was added, and the provision by which the consumer commission is supposed to refer dispute for mediations. That is couched in the same kind of language as well as section. So I will encourage you to look at the act itself and find out in your church, go to the consumer court, how is it functioning, whether they have actually created the operating system to make it functional. That's also the issue. So please have some field research been done, visit those places, find out what is happening there, and make an assessment, an academic assessment, whether it is actually so. Now let me also refer to a few other legislations in which this mediation has been inbuilt as something to be undertaken by the authorities of authorities. Now you have section 442 of the Companies Act, so section 442 of the Companies Act, and then you have Companies Mediation and Conciliation Rules 2016. Now remember the time value, 2016, 2019. So there is a band of period in which all these things are happening. And then you might look at section 32G, section 32G of the Real Estate Regulation and Development Act 2016, which also has a similar kind of provision. Then you have section 18 of the
Micro, Small and Medium Enterprises Development Act, MSME Act. That also makes conciliation of the dispute arises from payments to MSMEs. And obviously, you're all familiar with the dispute set, so I will not go into too much into that. So there is already a provision which is there, in which there are conciliation officers which are there. And you might even again look at it with what prompted the changes in the Illicit Disputes Act. Conciliations were already in place, even in 1947. And then later on, they had taken out the individual disputes in that category because the conciliation itself was taking good lot of time. But there is one thing more to this, which is that the training we have right now wasn't adequate. The professionalism which was there, which was not there earlier, is now existing. And therefore, even if the provision was there earlier, and nothing happened to that. But right now, that can be useless. For example, I'll give you one example. In the arbitration and conciliation, there is a complete chapter on conciliations. Complete chapter. But I have never seen one case in which, in the conciliation, within that act, although there is a process which has been prescribed, that if you want to get into conciliation, you need to know notice to the other party, the party will stop, you need to get a conciliator, and so on and so forth. And mind you, the act also provides that any kind of settlement which is arrived at through this conciliation process is also executed like any other court. But still didn't happen. Probably for the same reason that we did not have the professionals to make this into a court. Now let me just come to the mediation. Mediation Act is